How you doing, Robbie?
Good, Greg. How are you?
Good. All right. Well, welcome everybody to our live stream. Although I can see how many people are on, and it sort of jumps really quickly on there. But for a second, there was nobody there on there. Now there's people. I also have to sit up because I just noticed that you're like looking taller than me just because of the distance from the camera.
Am I
Um,
too close or too far?
you're fine on there. But anyway, so Robbie Rubin is joining me this week. We're going to talk about there's never a shortage. I mean, it's like I always like at the beginning, the week wonder. It's like I wonder if there's gonna be anything to talk about. And there were plenty of things. I sort of keep a little basket of in my inbox of things that we're going to be talking about, and there are plenty of them. Um, Mostly things relating to court stuff. And challenges and things like that are going on. Robbie's got the list. Robbie, I'm going to let you be the dealer,
Okay.
and you can dole out the topics, and you can say, "I will talk about this," or "Greg, why don't you talk about this?" So why don't you deal?
Okay. Well, let's start with something. Let's start with something very juicy. Um, and they're all current, but
It could be
how
many
about
things. Is it
uh,
Elon? Is it birthright
yeah,
stuff? Is it like what is it?
denaturalization? Yeah, the Elon Musk. On one side of the spectrum, there's Elon Musk as a potential target, and you have Mamdani on the other end of the spectrum as a potential target. So it seems like an equal opportunity offender type of
Yeah,
policy.
I mean, we thought that they were going to. We hadn't heard much on denaturalization in the administration up to this point, and was like, well, surely that is coming back as far as something that they're going to try and do. Um, but a couple things. So denaturalization was was basically slapped down by the courts as far as the way they were trying to handle it administratively. The courts are in charge of denaturalization, not DHS, not the executive branch. It's managed by the judicial branch. So when they say they're going to start denaturalizing people, they can say that. Now there was a memo that was issued recently in the month of June. I think it was like 2 weeks ago, maybe, and it wasn't very well noticed, but it was a white the it came from Pam Bondi, and it was basically a list of priorities for the Justice Department of all these immigration related. It was almost like they were like all immigration related things that are now their priorities instead of actually like.
Was this a leaked memo or was this a published memo?
I don't know if it was leaked or not. I mean, it was published, but I'm not sure if it was authorized or not as far as the
Right.
publishing of it. But the key takeaway was that it said that this was one of their big priorities for DOJ lawyers was to pursue um, denaturalization. So I think they understand that it has to go through the courts,
Right.
but it really is I think it's a real challenge for these Justice Department lawyers to pursue these things because if they even hint of doing things for political reasons instead of things that are actually based in, um, you know, what the law and the regulations actually have to say about denaturalization, I think there could be some pretty angry judges and some potentially referrals for bar complaints. Taking somebody's citizenship away is probably about, the most serious thing that you can do to a person short of a criminal sentence as far as taking. I mean, that basically strips them of all their rights
Yeah.
uh, on there. And, I remind people that that's what the Nazis used to do with during the
Oh, yeah.
30s. They would first strip Jews of their citizenship, and then they could do anything they wanted to them because they were no longer having any of the rights of a German citizen. Not that I'm not saying that that's what this administration wants to do. All I'm saying is that that's sort of a history of denaturalization and taking away. It's a very rarely used thing that happens. It's supposed to mainly only happen when people do things like serve as an officer in a foreign military. I mean, there's a small list of things that trigger denaturalization. One of them would be, however, if somebody committed, if you can document somebody committed fraud, material fraud, not just fraud, but material fraud that would potentially affect whether they could have gotten whether they could have gotten the benefits that eventually led to them getting citizenship. So if you could prove somebody made a significant, misstatement about their history on a permanent residency application, for example, that would have been enough if it was discovered at the time to have made them ineligible for permanent residency. And that permanent residency that they got ultimately was the basis for them becoming a citizen. Could that be the basis for denaturalization? Maybe. Again, it's rarely used. It's usually, and you have to show that it's that it is something that is that is pretty serious. I don't really understand. I don't know the Zoran Mandami's what they're accusing him of. I don't really know his immigration, his history and all that. I think he came when he was a child.
Yeah.
Uh,
I don't
I
think that.
I think that that's going to be pretty hard to denaturalize, even if they found that his parents committed some kind of fraud in getting the on air. I would not think that they would try and denaturalize the child who eventually got citizenship through parents, even if the parents ultimately did something that was made it eligible. So I think that's nonsense on his case if he came. But like I said, I haven't studied him. I just heard about that in the news this week with something ridiculous that the president said about him and trying to strip him of his citizenship or arrest him or doing other things. Elon Musk was the other person. Elon Musk, I think, is a more interesting case, mainly because if you followed the Washington Post series on Musk last year, they had done an extensive amount of research, and there were questions about whether he was complying with his student visa and whether there were misstatements. He encouraged people to make misstatements to come into the U.S. They're, in the grand scheme of things, not the worst immigration violations in the world, but they might have affected his ability to get permanent residency. If he was not really complying, if he lied about, when the dates that he was in school and all that. That being said, it would be exceedingly rare to go after somebody 20 some odd years later, or basically student visa violations and things like that. It's also possible that they were all cleaned up by a departure and a reentry to the U.S., and that everything after that departure and reentry was cleaned up. So even if he was illegal at one point and doing that, we just don't know. Who knows is probably Department of Homeland Security, which, I mean, I am guessing the White House has probably pulled Elon's immigration files and probably trying to figure out whether there's anything they can do with it. But anyway, I'm doubtful that they're going to pull that trigger because like I said, this has to go to a judge. The White House doesn't make the decision on this. And they have Elon lives in San Francisco. San Francisco has a lot of judges that do not like what they're seeing out of this administration, and they're not going to have a lot of patience for nonsense. And if they feel like this denaturalization stuff is nonsense, they're going to punish the DOJ lawyers for that. And Elon will probably be just fine. So, but I do take denaturalization seriously as far as that they might start combing through records and see if they can find misstatements and things like that. And I can certainly see it being used to get revenge on political enemies who've naturalized. That's something that I don't think anybody doubts this administration would have in their playbook. And we will see. The Trump administration says, even said, well, we're looking at it on there, which means that they're looking at it, and they wouldn't be looking at it if it wasn't Elon basically complaining about the administration. So it's clearly political. Yeah. Anyway, that's denaturalization. Fun stuff.
Just to wrap that up, the criteria that the memo from the Attorney General expanded.
found it.
Yeah, found it, yeah. Is that it includes it expands criteria of which crimes put individuals at risk of losing their citizenship. That includes national security violations.
Yeah.
Not sure what that
So
means.
that's something we were just talking about that before we went on the air. That is the thing that I think judges are going to be extremely reluctant to go down that road. But that's essentially what we're talking about there is like somebody like Khalil, the student who had his green card stripped on those kinds of grounds. And basically, what the argument is if it's national security grounds. But the only thing about that is it would have to have been to denaturalize, I would think, based on the way the statutes, you'd have to show that they were national security grounds at the time that they naturalized, that there were those kind of grounds. I mean, well, maybe. I don't know. I don't think is natural.
I don't think so. I mean, because I'll just read
I don't
other.
think national security is in the statute as far as something they could do after the fact. They can
Yeah.
put you in jail for doing
I think
things that are crimes.
well, espionage is like something you can be denaturalized for, right?
Yeah, that's not exactly the same thing that they're accusing any of these. I mean,
For sure. Yeah. No, I'm just saying. I think there's like it can come after the naturalization.
Yeah. Well, I have no doubt that the national security stuff is what they're looking at to kind of scare people, especially like, politically active immigrants into thinking, ooh, the administration can, I'm a naturalized citizen. They can go, that they can go back and basically undo everything because they don't like my political opinions.
Right.
I think the first person they try that on is going to have a big win in court. And I would say to people, it's like, don't lose your shirt over this. This is one that's going to be pretty tough for the administration. I mean, if they want to go after people for legitimate lies that were stated on applications,
right,
they probably have more room to do that. But if they're looking to go after people who they just don't like their opinions at this point, I don't really care what your opinions are, honestly, on that. Unless you are spying or doing actual terrorist acts yourself on there, you probably have nothing to worry about. But even if somebody, I'm not even sure if terror, like just normal crimes, was terrorism something they could? I don't think terrorism is something they could strip you of.
I remember, I don't remember, but they were like they're very it's like treason.
Hard.
It's like treason. Like they're very, yeah, it could be. I don't it could be terrorism. I don't remember. There's like a very few like elucidated
Yeah, I mean, they try and say everybody's an enemy and everybody's an invader and everybody's committing treason. I mean, those are terms they use over and over again. I suppose if you're in the wrong jurisdiction with a court that has some judge that is not particularly open-minded about free speech, then that would be an issue. But I think even in the most conservative jurisdictions these days, judges seem like they've grown a little bit of a spine on free speech issues as well as on due process issues on there. So all I can say is that it's like it's something that they put into this memo, but I don't think it's going to be a very easy thing for them to find cases that are going to be acceptable by the judicial system for what they claim to have in mind.
Okay. I just checked, Jen. One of the grounds that I didn't know about for denaturalization is refusal to testify in certain legal.
Well, you should share your screen and show like how it worked. Gen's the software that I was a co-founder of that product, and a lot of Siskind Susser lawyers have been involved with the testing of that since we did it. Do you have that? Do you know how to do that to share the screen? You go to present.
I'm gonna try.
You don't have to. If it looks like it's taking you too long, we'll move on.
Yeah, I think I got it.
I want to see what it. I want to show people what. Yeah, there you go.
Is that working?
Yeah. Oh, boo. Okay, I don't know what you just did. Yeah. So hopefully people can see this. It's a This is the AI product that I work on, and basically, it's for lawyers, but you can ask it anything on immigration law. It's powered by a law library that has millions and millions of pages of content, and it's we have a full-time curator who is updating it every day on there. Usually, every court case in the country on immigration, everything ends up in here every day. So it's usually
as you can see, it's by these dates, it's something that I use just about every day, multiple times.
Do you, by the way, look on those citations and see if it pulled up that DOJ memo. I'm just curious about whether that even made it in.
And that's what's another really neat thing about Jen, is that it doesn't just spit out information and that's random. It gives
you click on one of the sites.
Let's see if I can. Okay, so I don't know if it has. I don't know if it's gotten up the. But so here are the sites.
Oh, so yeah, it didn't pull from the new DOJ memo, but it might be because you don't have the AO link to it. Yeah. All right, we can move back on. I'm gonna. I think we have to There you go. All right. Okay, so what's our next topic, Robby?
What's a good one? We could go. Let's go to birthright citizenship and the recent Supreme Court decision.
Yeah, so that's not big news anymore, but I did want to kind of talk about it because we didn't really get into it as much. So basically, the Supreme Court was looking at an issue that's been bothering them for a while. And the birthright citizenship, unfortunately, seems to be the case that they decided to draw the line on this other issue. So basically, one of the things that district courts judges can do is they can issue a national injunction if they say that a policy is illegal and that there's imminent harm that's going to be created, and the plaintiffs are likely to win at trial. And it's a little bit of a higher standard for a temporary restraining order than it is for a preliminary injunction. They're sort of similar concepts, but basically we saw that all the time. I think we should sort of mention as well that this is not something that is strictly a partisan issue. That the Republican, you may recall from ancient history of 6 months ago, that Republicans were regularly suing the Biden administration to block his immigration policies, and they would file these cases in a district court in Texas where there was one judge in that district, and you were pretty much, if you were filing a case in that district, you were getting this judge, and that was a very effective way to stop a lot of Biden immigration policies. In the Trump administration, the first Trump administration, the latest Trump administration, the same thing is happening, where cases are filed with the hope that a judge will block it nationally. The Supreme Court doesn't like that. You may say, they're horrible partisans and all that. I don't think that that's the worst. You can attack it saying it's just giving the executive too much power. But it is not something necessarily that it's sort of policy neutral as far as like what it means. But what the Supreme Court did was they said that you couldn't do those types of injunctions anymore. But they, if you listen to the arguments, they seem to be open-minded about national injunctions in class action cases, which is basically after they've certified that this is a national problem and not just going on in that jurisdiction. Judges could still, by the way, issue injunctions for just their own district. So they could issue an injunction in the district of whatever, and then the circuit court to do an injunction for the Fifth Circuit on their whatever circuit they're in. So that is one way that this is being attacked, and there was already immediately actions to try and get the class certified, so that they could go back and do a national injunction. But
so in that case, Greg, so let's say you get do you just have to have plaintiffs from more than one state or more than one circuit, and then
No, I mean, a class so class actions, and we filed some of them with impact litigation. I mean, you have to find plaintiffs that are representative
right.
of the class, and you have to show that people all have sort of a very similar claim, that it's a very, that there's a lot of similarity from person to person as far as what the issue is. I think with birthright citizenship, that's a fairly easy case to make, and I think the Supreme Court probably wasn't all that worried about birthright citizenship because they knew that a class would be easy to certify. I think we had, I was also talking to you beforehand that there's also this is not the only thing a judge can do as far as a national injunction. If any of you read my LinkedIn feed, I posted an article earlier today, and I'm just kind of looking to see if I can find that, where there's a great article where was that article? That was in justsecurity.org. I'm going to see if I can post this link in our as a banner here. Let's see if I can do that. I'm trying to use tech again. All right. This is the article if you want a screenshot. But basically, what this article was pointing out is that in the Supreme Court case, there was language from Justice Kavanaugh in his concurrence that said that the claim was overbought and argued that plaintiffs broadly affected by unconstitutional executive action may, and this is a quote, under Federal Rule Civil Procedure 23B2, ask a court to award preliminary class-wide relief that may, for example, be statewide, region-wide, or even nationwide. So it doesn't have to be national. But also buried in his concurrence is a more direct and less costly and time-consuming alternative to seeking class action certification. Justice Kavanaugh essentially now guides every plaintiff currently suing to challenge unconstitutional executive actions as follows, quote, in cases under the Administrative Procedures Act, plaintiffs may ask a court to preliminarily set aside a new agency rule, and then they give Justice Kavanaugh gives a citation. Footnote 10 of the majority's opinion cites the same provision, but does not challenge Justice Kavanaugh's view, instead noting that nothing we say today resolves a distinct question whether the Administrative Procedure Act authorizes federal courts to vacate agency action. Thus, for plaintiffs challenging the administration's executive actions, the CASA case suggests that the APA may provide the way forward, which I thought was a very interesting observation, and it's a very interesting strategy I think a lot of people are going to use, where you don't necessarily have to say to enjoin a policy, but you can have them, temporarily set aside the policy under the Administrative Procedures Act under that provision. So,
arguing basically instead that the violation is procedural.
Right. So this APA rule and a vacator of agency action is what this article is talking about when there are executive orders that are potentially serious problems. So any lawyers that are watching this, but even non-lawyers that just want to read this stuff because it's interesting, go to this article that you're seeing on the link here. So that's on birthright citizenship, though. It is interesting because let's just say that they don't get another injunction, or let's just say this APA thing doesn't work and they're kind of stuck on there. It is just kind of a crazy thing because it would literally invite thousands and thousands of individual lawsuits, which may still be coming after 30. If this is not enjoined but before the 30 days, the court gave 30 days for this to take effect. If this is not enjoined by them, there's something like 300,000 children a year that are born that are potentially affected. Most of it's like 3/4 of them are children of at least one undocumented person, but the rest of them are like children of non-immigrants, which is a huge number. And I've been getting questions more from the non-immigrants asking about that. What I would tell people for right now is a reminder. First of all, it's only for going forward. This executive order came out in January, and they said it was only children that were born after the executive order was issued. Second of all, I would just take a breath and just see what happens in the courts over the next 2 to 3 weeks, and see how they react to this. It looked like, my sense is that the Supreme Court wanted to deal with this issue they saw as a problem, these national injunctions, but they didn't really. They wanted to make, a relatively straightforward avenue to challenge the birthright citizenship order. So my guess is that the judges, the justices rather, that voted in the majority on this are assuming that birthright citizenship is going to be struck down another way. That's not actually going to happen. That is my optimistic take, and I'm an optimist, and that's kind of a joke around the office. But I do think that's that for people that are asking me about it, I'm like, I'm not discussing it with you right now, because I really have no a sense that this is going to go away. And at worst, we'll go to court for you and get your kid's citizenship restored. But I don't think any individuals are going to be having to go. But impact litigation's ready to do these mass actions if needed on there. We can do it, but I'm optimistic that that's not going to be necessary.
Yeah.
All right. What do we got next?
Well, speaking of impact, we could talk about some good news we got this week.
Yeah. Today.
Today.
I like seeing it in the news today. A case of ours was actually making news today. Instead of us talking about what's happening in other courts cases, we can talk about our own case.
Yeah.
So why don't you talk about Doe v. Nome?
Yeah. So as we've discussed, I think pretty often throughout these live streams, impact litigation filed a lawsuit in the Northern District of Georgia on behalf of, I think the 360, maybe it was, I think the final numbers are 358 plaintiffs who had their CVIS accounts terminated all around like early to mid-April, most of them, and also their F1 visas revoked as well. So we filed a lawsuit arguing that the terminations and the revocations were done without due process, and that that ICE, for a variety of reasons, that ICE doesn't have the jurisdiction to make these unilateral terminations. So at this stage, of this settlement, we agreed. The government essentially conceded on basically every meaningful ground we were asking for in our settlement. The government conceded to. The only thing that is still outstanding is the lawsuit regarding the reinstatement of the F1 visas and F2 visas themselves, because that's sort of a separate matter that's going to have to be pursued against the Department of State. But as regarding this, and I can talk about that in a minute, but regarding the CVIS settlement, all plaintiffs have had and many plaintiffs and many students throughout the country had already had their CVIS accounts reactivated. What was, I think, maybe one of the more significant things that was achieved through this litigation is that USCIS, ICE has agreed that the days from the termination until the reactivation of their CVIS status, which for most people was about 6 weeks, which can be a significant amount of days for people. You can only have up to 90 days of unemployment days if you're using OPT for your work authorization as a graduate, after you've graduated from university. So some of the plaintiffs consulted with me privately, because they had already accrued 65, 70 days of unemployment for whatever unrelated reasons, and then all of a sudden now there's in their CVIS account, their unemployment tracker is showing 100 days, and they're going to file for their extension, and they're like, well, how am I supposed to handle this? So the settlement that we agreed to with the government stipulates that the government will not be, it's resetting it to active, and it's also retroactive to the day that it was terminated. So that way those days aren't counted as days of unemployment.
Retroactivity was really key to us in this, that we wanted to leave our plaintiffs in exactly the shape that they were in before this mess started, and that they shouldn't have any lasting damage.
And if anything, they're arguably in maybe better shape, because I think the government stipulated to certain protections against future terminations as well.
Yeah. It was really I think a very satisfactory
and swift and very
settlement.
Swift,
so that was good, and we appreciated the everybody, that the government recognized on this one that this was not a one to fight with us. We did have to separate out the State Department suit on here, because what we have done is we have agreed to dismiss with prejudice, meaning that we can't raise any more claims that are sort of related to this action with respect to these plaintiffs in this particular case. But we didn't want to give up our claims with respect to the visa revocations. So part of what we agreed was that we were going to basically take out the claim against the State Department in this particular case, so that when they dismissed it with prejudice, that was no longer part of the case, and that's not covered by that particular clause. So that's like legalese basically saying that we preserve that issue to fight another day, and we are about to start onboarding to a new suit. That is just going to be against the State Department, just on visa revocations.
So what's going to be a big difference between this suit, this suit for the visa reinstatements, and the original SEVIS suit, is for the SEVIS lawsuit. When we ended up only asking for SEVIS reactivation, we only were able to include plaintiffs that were in the United States. So, and Greg, correct me if I'm wrong, but I believe that with this when we're making the arguments on reactivating visas, that we'll be able to expand our pool of plaintiffs that beyond people that are just in the United States, people that left after they had their SEVIS accounts deactivated. So we're days, if not a day, away from going live. It's already on. If you go to the Impact Litigation website that Greg linked to on the banner, you can see that all the onboarding information is on the website for the DOS visa reinstatement.
Yeah, I just checked. If you click on the so basically,
it's not live yet.
You can go there to read what the case is about and how it's going to work and everything you need to know. We believe, Robbie, you were testing these apps today, and they all are fine now. And I think Adam Cohen, who is one of the lawyers that is working on the student stuff with us, he just texted me that we should be hopefully live tomorrow with all the apps on there, if there's no last minute problems discovered. That's the thing about sort of these cases now, is we have a lot of tech involved with the onboarding, especially when we're onboarding a lot of people. It makes it easier for us to act much more quickly on behalf of a lot of people. But if you are a student who had their visa revoked, you are welcome to join the case. If you were in the previous case that we filed in Atlanta, you're one of our 358 plaintiffs, you are invited to continue in the case, and I think we're asking for a new engagement letter, but you won't have to and a new declaration. So you're going to have to go through the onboarding again. You won't have to pay to be a plaintiff in the case like new people would be. But if you are one of our existing plaintiffs, we definitely want to keep you part of this litigation. And like I said, it's easy for you to do that. You just have to basically do the onboarding apps, and then you're essentially done. But those should be live tomorrow at impactlitigation.com.
And I would, even though it's not live now, there's a lot of information on the onboarding portion of the website that is probably worth reviewing, if you're considering joining the litigation, it's worth reviewing it. The FAQs are live, so that really, the FAQs there will have all the information you really need to look through and you can, make a determination on your own, or there's information there on who to contact if you have any questions about your eligibility, so you can get a head start.
And I don't know, before we're done with that, I want to talk about the other impact case that just started onboarding as well.
That's TPS?
Yeah. So Venezuela TPS, we're intending to litigate on various TPS cases. There was actually a TPS case that made news today on Haiti, or I guess that was yesterday, on there, where there's been a national injunction blocking Haitian TPS, but I'm not sure if it's. I think I haven't. I think that was done on a class basis, but anyway, it was done after the Supreme Court decision was made, so obviously it was done with the intent to comply with that. We are preparing a mass action for Venezuela 2023 TPS recipients, and they were announced in April that that program was ending. So what we are looking at is, if we are, the Supreme Court said no national injunctions, we can still do a mass action and get a judge to block the ending of TPS and EADs for our plaintiffs, and we can potentially, and we'll seek class certification as well. But we have we're basically taking the Trump v. Casa case, Casa v. Trump, to heart on that. And if there's there was a national injunction that was blocking TPS for Venezuela, but we are offering an alternative to that case and allowing people to file a mass action, which the Supreme Court decision had nothing to say about. So we believe that we have we have a good argument to make that this essentially TPS can only be withdrawn by a president after they've kind of gone through a process and demonstrated that whatever was the cause for the TPS designation happening in the first place, that's no longer a problem in the particular country. So you can imagine why Haiti TPS was going to be a very hard thing for the administration to defend. Venezuela as well, where they're saying basically all of Venezuela is run by gangs and by invaders, and if it's in their travel warnings for the State Department about Americans going to these places. So that's the essence of it, is that they haven't shown anything other than just having an abhorrence for TPS, but they haven't gone through the process of showing why it should be removed, why TPS should be removed. I should say that the Trump administration tried and failed to remove TPS for several Central American countries in the first Trump administration on that issue, that they were not able to show that the country conditions had improved enough that it was safe for people to go back. So that's the other case that you'll see if you go to impactlitigation.com if you're Venezuelan.
And that one is live. That one you can.
Live. The other cool thing that we did on that was this is the first time we've done English and Spanish as far as our apps go. So a person that can go through and filling out the app in Spanish and seeing all the questions in Spanish and have everything done that way. So that was kind of fun for us to do that for the first time on any of these cases. All right, what do we got next?
What do we got next? We had a ruling today from Judge Moss, I think from DC Circuit, about
it was like an almost 200-page decision that came out on today. This was this one hurts for the Trump administration. I feel like on there, because what we're talking about is they essentially barred people from seeking asylum at the border.
Right. Well, they tried.
Right. And the judge today said that's baloney, and that's not. You can't do that by executive order. There's a lot of statutes and treaties and all that regarding asylum, and you can't do things with. They were basing the whole policy on the same thing with the Alien Enemies Act, that there's been an invasion and that there's a national security reason because of this invasion that's happened on here. So as we've seen in several courts, they haven't bought the invasion argument in Alien Enemies Act cases. The Judge Moss wasn't buying it either in this particular case. And he did do one favor to the administration, which is he said that he stayed his order for 2 weeks to give the DC Circuit Court of Appeals a chance to weigh in on it. So it is possible that the DC Circuit will weigh in. And it is also possible that if the DC Circuit, I just noticed I have a spelling error on the screen. If the DC Circuit weighs in, with it weighs in, that we could see the Supreme Court eventually have something to say about it as well on there. So it's far from over, but it is not that certainly you can't be called good news in any way for the administration on there. I didn't this case has quietly been working its way through the court, and I don't think people really saw this one coming. Just kind of came out of the blue. So that was an interesting one today, and I think that's one that's probably triggered meetings in the White House about how to respond.
Another, and I don't want to, Greg, you can cut me off if you think this is going to just scare people too much. But we've been seeing trends of people who are in what we've always assumed to be grace periods, between H-1B extensions or changes of status, grace periods that technically are discretionary, but at no point, I mean, I've only been doing this for, 4 years now, but, my colleagues have been doing this for decades, and this has never been.
Well, the grace periods have only been around since 2017.
Okay.
So they're not that many years. That was actually an Obama administration regulation that was in place. But also, I had heard on some of these cases that people had filed already for changes to visitor applications and that they were still ignored. But basically what you're saying is that people that were laid off or terminated for one reason or another, as soon as the notification was received by USCIS, that they notified ICE, and ICE issued a notice to appear for removal hearings.
Which is just, that's pretty chilling. I mean, that's...
Yeah. So, it's leaving us, first of all, I believe probably there will be some very quick federal litigation on that particular issue, because that seems like that they haven't even adjudicated the question they should, to take any action before 60 days under the regulation. They don't have to, they have discretion to approve a change of status if it's filed within 60 days. I don't think they have the discretion to issue a notice to appear until the 60 days are up, to at least give the person the opportunity to make their case.
Right.
Now, I think that what they could do is basically give somebody 60 days and then say no, and then put them into removal proceedings as far as the a late filed extension. But what a person could do, in that period of time, is that they could potentially exit the country, file for a new action, and then as soon as it's approved, re-enter with the new approval notice. That might be sort of the new way going forward, that people are going to have to act in those particular cases. But putting somebody into removal proceedings is essentially making it impossible for them. I mean, you could be here for many, many years if you're in removal proceedings because they're so backed up in the courts. But it's probably going to be a long time before you have a work authorization document. You're not going to be most employers are going to be pretty freaked out about hiring somebody that is in deportation proceedings, wanting to basically understand why. It's just so I would probably think if this happens to anybody, talk to your lawyer about federal litigation on here. And I would think that you can potentially get a declaratory action or something similar basically saying that that policy of doing that is itself illegal, and they have to basically quash the or whatever the term is for basically killing the notice to appear, and giving the person an opportunity to file a late filed change of status as long as it was done in the 60 days. I would also think, in terms of the way relief is shaped, is basically the person's so distracted at this point now from being able to look for a job by having to deal with the removal proceedings, the judge might have to get more aggressive in terms of shaping some kind of relief. But I think USCIS should know that they're treading on very dangerous waters if this is if they think they can completely toss out that regulation, without without going through a new rulemaking process.
What it almost seems like to me is that we're seeing kind of like a whole of government approach to that's trying to like encourage people to consular process, to do, whether it's a non-immigrant or immigrant visa, they're kind of like wearing away at like all the processes that lets you stay, remain in the U.S. in an authorized period of stay. You can get, people have been gone to, marriage-based interviews and have gotten, detained. And it seems like they're emphasizing a shift towards doing everything at, through the consular process, which is.
Yeah, although, I mean, I still think with the old days, we would basically file for somebody to enter visitor status, and to switch to B1, B2 status, because interviewing for jobs is a acceptable business visitor activity. So it's not fraudulent to do that. That's a perfectly legitimate reason to request that status. And we would tell people, we would tell USCIS or INS even back in the old days, that this is what happened. We're filing this so that this person wants to leave this job, and they need a couple of months to go through the interview process because they're in a high level position that requires some time to go through recruitments. It's not, if you're some super specialist in some kind of, major scientific field, finding the right lab and finding the right people that you're going to work with and who's going to give you the right equipment, blah, blah, blah. On there, there's a lot of reasons why it can take several months to find a new job in fields that are more complicated. That's a good thing on there. You want to, you don't want to lose those people who are doing the most hard to find, have the most hard to find skills. Okay, so be on the lookout for that, folks. If you are, if an employers and lawyers out there, if you're getting wind that an employer is going to lay off somebody on a visa, that's the other thing here is that you can oftentimes plan around this and give somebody some notice that they. There has been a trend in the workforce for many years where people like to terminate somebody without notice and escort them from the building because they're afraid they're going to raid the computers and they're going to get trade secrets and all kinds of things like that. But we need to actually go back to the old days where, somebody gave notice, or you wanted to get rid of somebody and you gave them a period of time to basically look around, because it is always easier to find a new job while you're employed versus unemployed on there. And that was more common years ago when I was practicing for employers to do that, versus now where they do it without any notice and they immediately escort you from the building on there. And they're not doing it because the person that's being fired did anything wrong. They're just doing that because that's what their protocol is for everybody, that they terminate. And I think employees have sort of gotten used to that as well, that that's kind of a normal thing. If you're being terminated, you got to be you're out of the building that day. So that's employers have some ability to make this problem less serious if they would just not terminate immediately and notify USCIS. You also have to notify USCIS if you terminate somebody, but there's not a set deadline, I don't believe, for that. So it just has to be done in a reasonable period of time.
think it depends on the status. Like I think with R1, I think it's 14 days.
Right. But that's not it. But there are some statuses where I think it just has to be done within a reasonable period of time on there. And that might be enough. You don't have to notify the day you terminate. That's, so you can give somebody enough time that they can already have a new application pending before you notify the termination. And you can sometimes make terminations effective on a certain date, even, and the person can be out of the building on that particular date, but still be on your payroll for a period of time, and still technically employed. So different things that you can do. Talk to if your employer, talk to your immigration lawyer about what your options are, but don't assume that there aren't going to be seriously bad consequences for your employees. You're assuming that this grace period is going to cover them. No longer assume that grace period is going to do what everybody thinks it does.
Another thing that we talked about, we wanted to talk. I didn't even know that. I never even heard of this. Apparently, there's something called a Senate parliamentarian.
Oh yeah,
I never even.
This was my favorite news.
I didn't know that. What is that? But I don't know what that is, and you can.
So let me explain what happened here, and I don't know if you can. My insider did a good job summarizing what the issues were. I'll see if I can find that email in a second. But this big beautiful bill that passed the Senate yesterday had immigration provisions in it. But here's the thing: the Republicans have a very slim majority in the Senate, and there's this thing that they don't want to get rid of called the filibuster. And the filibuster says that the minority of senators can block a piece of legislation if they can get 40 votes to block it. And the Republicans love doing this against the Democrats when they had control of the Senate. The Democrats have certainly used it back. They both parties love it. I'm not sure I love the filibuster as a general rule, but that is what it is on there, and that's what it is. But basically, there's an exception to this filibuster requiring only 40 votes, where you can stop anything. Otherwise, Democrats could stop anything that Trump was doing. There's an exception for basically spending bills, and a spending bill can get approved by just a simple majority. And the Republicans can put together if the Republicans can get everybody to vote, they can usually get that simple majority. The problem is that there's this parliamentarian, and this is basically the referee, and the referee in the Senate is basically says if a bill you can't just throw everything into the spending bill if they're not truly spending measures. If they're not really just about how much money you're going to spend on something, and they're more policy things that you're trying to slip in and call spending, I'm going to basically rule that these are.
And who is this? Is this like an elected official? Is this an appointed?
No, this is a. I'm going to tell you something. That will.
Oh, this person's been doing it for the past 13 years. This is
she's been in there a long time, and she is. There were a lot of Democrats that were mad at her in 2021 because there was a really nice immigration bill that the Biden administration was trying to pass in the Senate. They were trying to throw in some really nice immigration provisions into a spending bill, and it was going to include a lot of things that were going to deal with making more green cards available for high-skilled workers, and there were things in there that were going to deal with legalization for a lot of people. I mean, there were a lot of things that people would have loved if you're pro-immigration that were in there, but she ruled that, and she was probably right, that these were not really these were policy choices that were being put into the spending bill. And there's always, it's a little bit of a fine line as far as what that is. But she did come up with 5 things. Do you have a list?
I do.
5 things.
Yeah.
So she nixed 5 things from the Senate bill that were pretty significant on immigration. And maybe you can talk about what didn't make the bill because the parliamentarian was able to get them taken out. So that was a good news story for the week.
Yeah. So a few of them are pretty similar. So she was able to strike out all of the provisions that delegated state and local law enforcement the power and authority to enforce immigration laws.
Right. Sanctuary city stuff.
Well, so that's so the sanctuary city is a little separate because there was a part of the bill.
This is the reverse sanctuary city stuff to try and like make it easier for states to do this stuff.
Correct. Exactly.
Right. But it was the same idea, which is that they were trying to basically reward their states and cities that are their friends and hurt the states and cities that are not their friends.
Right. Right. So it would have allowed. So this is just from the bill. It would have allowed states to conduct states and local law enforcement to conduct a border security and immigration enforcement, which are roles traditionally exclusive to the federal.
We could bet that our state would have been probably the first to take that up.
Tennessee.
Yeah. Well, any of these other states.
Some border states. Yeah.
Yeah.
And then the other one that I thought was also interesting was she removed provisions that would have blocked federal funding to sanctuary cities and states.
That's the one that's the one that probably really upset people in the White House.
The parliamentarian ruled that conditioning funds on immigration policy compliance is a policy change unrelated to spending and budgetary outcomes.
Yeah. So that has been one it's been a consistent loser for the administration and the courts because the argument is that these funds were appropriated and Congress didn't give you permission to withhold these funds because they were so-called sanctuary cities. So the Senate wanted to basically fix that by saying, you do have our permission to do this. And that would have made it really hard for these cities to win in court. I think if that provision was in there, those sanctuary cities cases would have been really hard to win on there. But now that they are out, that kind of is a big boost to the plaintiffs in those cases.
Yeah. And then the one final one that was removed was a provision that would have stripped SNAP benefits from non-citizens from receiving SNAP benefits, which
it's food stamps.
Yeah, food stamps.
Right.
So yeah, that was.
Yeah, I think non-citizens. I mean, we're talking there as permanent, like potentially. Is that permanent?
Yeah, it's interesting. I don't know that language. Yeah, I don't.
Yeah. So anyway, so there were 5 of these provisions that were stripped out. Now, with that being said, the House has a difficult job because they know that if they make any changes on the House when it goes back to them, because the House version of this bill and the Senate version of this bill are very different. The House makes any changes to the Senate bill, then it has to go back to the Senate with the new version. And they barely got this agreement there. But the problem on it is there's a bunch of changes that the Senate made to this bill, which upset House members. So there's already a lot of people thinking that there's no way this is going to. The House majority is more of a problem. They had a 3-seat majority in the Senate, which is a little easier to work with than the 4-seat majority that they have in the House when we're talking about 435 members in the House versus 100 members in the Senate. So they can really afford to lose nobody in the House, and they have to convince all these House members that had big problems with a lot of them already have said that there's just no way. And then to kind of, I guess, to throw the icing on the cake or whatever metaphor you want to use, Elon Musk is so upset about this that he said that if there's any Republican that votes for this, his opponent is going to get money to primary him. Now, Trump has also said that anybody who doesn't vote Trump's way, he's going to primary him and all that. So there's like no win. So, I mean, basically it puts people in this situation where it's like, might as well do what I want because somebody's mad and somebody's going to be
Yep.
spending money to try and get rid of me, whichever way I vote. So I might as well just vote the way I think my constituents are going to be happiest on there. So we will see.
Greg, would you like to take a guess at how many pages the Big Beautiful Bill is?
2,000 pages?
940.
Oh, that's not too bad.
It's not too bad.
Yeah, we'll see.
We've seen worse.
We've seen worse. Actually, there's so many horrible things in this bill about so many other things in the, we talk about immigration every week, but
Right.
there's just like so many things that are in this bill that are going to affect, like,
Medicaid.
people are not going to like really have an understanding about how many things in the daily life of Americans are affected
Yeah.
by what things that are in this bill. Plus, it'll blow up the deficit at the end, which means our children and our grandchildren are going to be paying for this thing for a long time if it actually happens. I think most Americans are pretty upset about it already, but they seem to be committed to going over the cliff on it. But we'll see next week when we come back. We'll see if this thing has actually happened. The president says he wants to have it on his desk by Friday for the 4th of July holiday. I think they will have a vote by Friday. I say right now, if I had to lay odds, I still think it's no better than 50-50 that where this thing's going to become law.
Yeah.
So we will see. Are we? Have we run out of topics? It's 8:00.
It's 8:00. I can just give what we can
give the headline. Give the headlines.
Yeah. So there was one good, in our opinion, piece of news. There was a Indian J1 PhD at Georgetown University, who was detained by ICE. Not exactly sure when he was detained, not so long ago, citing, really, the same type of
his personal politics.
Same type of grounds for Mahmoud Khalil, and adverse to national foreign policy and national interest and all that. And this week, he was the courts held that he is not, that the ICE he has to stay out of ICE custody, because not only did the government find that he was detained, for retaliation of his, expression of his First Amendment rights, the government even conceded that is why they detained him. So good news to hear that he was released. Whether or not, again, you agree with whatever he might be saying.
Well, I mean, they're taking this position that, national security, that free speech and national security can't coexist on here. And that's the, and that's really what all these cases are about that we're hearing, not all of them, but a lot of them basically come down to that issue, the denaturalization stuff that we were talking about before. These, the students at several, in the Khalil and this, they all come down to basically saying that your free speech, if you're an immigrant, you don't have free speech rights the way you do.
Although even as we talked about in the beginning, even citizens maybe now.
Yeah, well, I'm not sure. They're probably trying to figure out a way to actually get rid of native-born U.S. citizens too. The natural, that's what it essentially comes down to, is that they are trying to block speech on there. And I've said it before. It's like, I'm not going to get into my personal politics here, but I do not. There have been a number of people that have been attacked by the administration, and it was like, I don't agree with the damn thing they have to say, but it's like, for goodness sakes, they have the right to say it, and that should be the end of the story on it, and the end of discussion. And that's, that in my opinion is probably the view of most Americans that take the Constitution seriously, which is that you can condemn the speech all you want on here, but saying a person has no right to say it is not American. That's un-American.
Correct.
We're talking about making America great again, and sort of like making America great again would be basically reinforcing the principles that made America great in the first place on there. So, Robby, I can't let you stop. Robby's a huge tennis fan. Well, you're a tennis player. I don't know if you're a big tennis fan.
Both.
But I was watching Wimbledon today, and I have to say, sort of I was like wondering like what my instinct was going to be. I always sort of have this thing where whenever I don't even like know who these players are, but they have the American flag, next to their name and on the screen, it's like I automatically root for them just because they're Americans and all that. And I was like, am I going to feel differently, about that, or I'm going to be more international, all that? And it's like, no, I was like rooting for every American out there. And I was like, but I do sort of get, sort of like I was thinking, it's like these poor, these Russians and Belarusian players, they don't even show their flag.
I think it's time.
Afterwards. And I was just thinking, it's like, is that how the rest of the world's like looking at us now, where they would like to basically, take the flag away and basically make our players have to compete under no flag? I mean, are we basically, is our reputation being shot so much around the world that nobody's rooting for the Americans except for the Americans themselves? Yeah. It used to be Americans. There were a lot of people out there who were just rooting for Americans because they love the country. And I'm like, that's the saddest thing about, I think, what's happening right now is that I think a lot of people that just love Americans, and when you go abroad and all that, there are a lot of people that just as soon as they find out you're American, they want to have conversations with you, and they want to talk about culture, they want to talk about sports, and they want to talk about everything. And it's like, are they now like looking at us like, anyway? So that's I was thinking about that today when I was seeing the American flags there and then the no flags.
Yeah, the no flag. I think
those players, and I felt bad. I feel bad for the players in those countries because they have
nothing to do with it.
The announcers won't even say what countries they're from on there. If you know, they just talk about them as individuals as if they don't have a country that they're from.
An actually interesting thing that they do is that if a Ukrainian tennis player plays against a Russian or a Belarusian.
Yeah, there was somebody doing that. There was a Ukrainian versus a Russian today.
Oh, it was? So after the match, I don't know if they showed it, but after the match, they don't shake hands, and they put up a like sign on the Jumbotron saying, explaining, out of respect to the situation with the armed conflict in between Russia and Ukraine, the players have agreed before the match that they will not shake hands afterwards or something.
I don't like that either.
It's ridiculous. It's just, it has nothing to do with them. These are people.
Yeah, I think they should check it. There's that famous incident. I mean, I think it was an Iranian and Israelis at the Olympics or at national like wrestling competitions and all that.
Judo.
And they were I think it was the Iranian, basically forfeited. I mean, they would forfeit the matches rather than even compete with and it's like we would hope that sports is like the one place that we can get past that. Anyway, we can talk about more about that another day on there. But anyway, thanks everybody for watching, and we'll end it here. And should be back next week. I don't know what combination there will be. I'll probably be back. I like doing this every week. But Robby, you're always welcome back anytime you want.
Appreciate it.
Come on back, and we'll talk about next week's news next Wednesday night. Thanks, everybody.
See ya.